Good morning. This is your Kelso Report for Thursday, November 3rd, and I'm your host, Clark Kelso. Well, all we have today are 3 one-liners. Our first one in the area of immigration law. In Garcia versus Holder, the Ninth Circuit held that the petitioner, who was paroled into the United States by virtue of the filing of an application for lawful residence as a special immigrant juvenile status, thereby qualified as having been admitted in any status, which meant the petitioner satisfied the requirements to be eligible for cancellation of removal. The government argued that the petitioner was not actually admitted into the United States, since he was technically paroled into the United States. But the Ninth Circuit rejected this argument, holding that the Special Immigrant Juvenile Parole Program was narrowly targeted at a specific class of juvenile aliens who must meet heightened eligibility requirements, and that under these circumstances, the petitioner qualified as being admitted in any status. Next, a constitutional law case involving equal protection. In People versus Ruffin, the 5th District held that equal protection was violated by imposing upon the defendant a lifetime sex offender registration requirement because he was convicted of oral copulation while being confined in state prison. Now, the way California's statutes are drafted, a prison inmate who commits an act of oral copulation with any consenting adult is subject to mandatory lifetime registration. But a prison guard who commits an act of oral copulation with a consenting adult who is a prison inmate is not subject to that registration. The court could not find any rational basis for making this distinction. As the court explained, quote, "We perceive no reason why the legislature would conclude that prison inmates who commit acts of oral copulation with consenting adults, as opposed to prison guards who commit acts of oral copulation with consenting adults who are prison inmates, constitute a class of particularly incorrigible offenders requiring mandatory lifetime registration as sex offenders," close quote. Now, I know this all may seem somewhat odd, but in fact the court's holding here is consistent with the California Supreme Court's decision in 2006 in People versus Hofshire, where the court held that it was unconstitutional to require someone convicted of oral copulation with a minor over age 16 to be subject to lifetime registration, when having sexual intercourse with a minor over age 16 does not lead to a lifetime registration. Now, on all of this, I think it's fair comment to note that our statutes dealing with sexual activity still retain a number of historic peculiarities that have not yet been fully rationalized by the legislature in light of our more modern approach now to the subject of sex and sex activities. Our last case is an anti-SLAPP case in Alpha and Omega Development versus Willock Contracting. The 4th District affirmed the trial court's decision to grant the defendant's anti-SLAPP motion as to the plaintiff's cause of action for slander of title. The slander of title claim challenged the defendant's filing of a lis pendens against the plaintiff's property as part of the defendant's effort to foreclose a lien to pay for construction work the defendant had performed on the property. The plaintiff conceded that the filing of the lis pendens was protected activity under the anti-SLAPP statute, so the only issue in the case was whether the plaintiff satisfied its burden of establishing a probability of prevailing on the slander of title claim. Well, unfortunately for the plaintiff, the law is well settled that a properly recorded lis pendens is absolutely privileged under Section 47 of the Civil Code, which is California's so-called litigation privilege. Given that privilege, the plaintiff could not establish a probability of success, so the 4th District affirmed the Superior Court's decision to grant the defendant's anti-SLAPP motion. And that's it for today's Kelso Report. Hope you have a great day in the law.